Hi everyone, today's session the unit is contract law, and we'll be looking at learning outcome 2, which is to understand the rules that govern the content of a contract. Now, in the last session, which was learning outcome 1, we looked at understanding the principles of formation of agreement. We looked at the issue of a difference between an agreement and a contract, and we also looked at the formation of a contract. We looked at offer, acceptance, ITT and capacity, but we also referred to case law when we were looking at these elements. So now we're looking at the understanding the rules that govern the content of a contract. So we'll start with the key terminology, which is what is a term? A term is a promise as to the truth of a statement written or oral made during negotiations leading to a contract. Maybe a term of the contract or merely a representation of including the contract. Representation. There is no promise, but the statement induces the making of the contract. A representation is something that is said by the offerer in order to induce the offeree to enter into the contract. It may or may not become a term of the contract. The distinction between terms and representations is important because if a statement is untrue, the remedies available to the innocent party may differ. If the representation becomes a term of the contract, the innocent party has remedies for breach of the term as well as for misrepresentation. If, however, the representation does not become a term of the contract, the innocent party will have remedies only for misrepresentation, which are based on equitable remedies. So 2.1, compare and contrast terms and representations. Statements made during the course of negotiations could amount to a contractual term or a representation. It is important to know whether a particular statement is a contractual term or if it is a representation, as this will determine the appropriate cause of action and remedy available. If the statement amounts to a term of the contract which is not fulfilled, the innocent party may sue for the breach of that contract. If the statement is merely a representation which turns out to be untrue, the innocent party may bring an action for representation. So a misrepresentation is a false statement of fact or law which induces the representee to enter into a contract. Where a statement made during the course of negotiation is classed as representation rather than a term, an action for misrepresentation may be available. Where the statement turns out to be untrue, there are 3 types of misrepresentation: innocent misrepresentation, negligent misrepresentation, and fraudulent misrepresentation. The effect of finding of misrepresentation is the contract is voidable. For example, the contract exists but may be set aside by the representee. The remedy available depends on the type of misrepresentation, but generally consists of rescission and/or damages. The right to rescind the contract may be lost in some circumstances. The law relating to misrepresentation is mainly found in common law, with the Misrepresentation Act 1967 providing some further details. The sources of terms are summarised in the following diagram. So we've got expressed and implied terms. The expressed ones are contained in the contract, or written or oral. The implied ones are by statute, by the courts, or by custom and usage. So terms of a contract set out duties of each party under that agreement. The terms will be of 2 kinds: express terms, and these are laid down by the parties themselves. So if they decide to put any sort of clauses or any terms in the contract, they could do that themselves. Implied terms, and these are read to the contract by the court on the basis that the nature of the agreement and the parties' apparent intentions, or on the basis of law on certain types of contracts. Generally, the terms of a contract may be either wholly oral, wholly written, partly oral, and partly written. Terms are to be distinguished from statements made prior to the contract being made. 2 main types of statements are a representation about a state of affairs or a promise that something will or will not occur in the future. Either type of statement can become a term of a contract, whether or not they are oral or written, or partly oral and partly written. Express terms. Oral statements. The key issue is whether oral statements may, during negotiations prior to the conclusion of the contract, become a term of the contract or remains mere representation, which is a promise. This is a question of fact. Courts look at the wide range of factors. Importance of a statement. So if the statement is important, then a party would not otherwise have entered into the contract. The statement is likely to be viewed as a term. For example, is the case of Bannerman and White, 1861. And the facts of this case are that Bannerman formed a contract with the defendant, White, regarding the purchase of hops intended to use them to produce beer. The claimant specifically inquired as to whether the hops had received a sulfur treatment, as it is only possible to make usable beer from hops that have not received this treatment. Furthermore, the claimant expressly stated that he would be unwilling to buy the hops if they had been treated. The defendant assured the claimant that the hops were untreated. However, in fact, the hops had received a full sulfur treatment and were subsequently useless to the claimant. Thus, Bannerman brought an action against White for damages, contending that the statement regarding treatment ought to be viewed as a contractual term, which White had thus breached. The issue in this case was whether the defendant's assurance regarding whether the hops had received a sulfur treatment constituted a representation or a contractually enforceable term. The court found that the claimant viewed the matter of whether the hops had received sulfur treatment was intended a contractual term rather than a mere representation. The court placed particular emphasis on the fact that the claimant had communicated the significance and consequence of the treatment to the defendant, meaning that they were reasonably aware of its importance, and the claimant was only contracting on these grounds. Timing of the statement. Generally, the more time between statement and conclusion of the contract, the less likely is the statement to be held a term of the contract. And this was the case in Routledge and McKay in 1954. The fact in this case is that the claimant acquired a Douglas BSA motorcycle and sidecar by exchanging another motorcycle and paying £30. The registration document stated it was a 1942 model, and this is what the defendant stated the year of the motorcycle to be when the claimant came to look at it. The motorcycle was in fact a 1936 model, but had been modified and re-registered by a previous owner. The purchaser went away to think about it and then returned a few days later. A written agreement was produced to the effect of the exchange, which ended the words, "It is understood that when the £30 is paid over, this transaction is closed." It was held by the courts that the statement was a representation and not a contractual term. The registration document was prima facie evidence of a contractual term. Neither party was an expert, and there was a lapse of time between the making of the statement and the entering of the contract, giving the claimant the opportunity to check the statement. Furthermore, there was no mention of the date in the written agreement, and the words of the agreement stating the transaction is considered closed, excluded any possible collateral warranty. So timing factor is a point of departure. If the statement is otherwise strong and important, then this may override significant delay between when it was made and when the contract was made, also as in the case of Showell and Reed. Oral statements, the strength of the statement. The more emphatic the statement is, the more likely it is to be viewed as a term, as in the case of Showell and Reed and AK and Godfrey. Special knowledge and skill of the party. So if the statement made by the party with special knowledge and expertise on the matter, courts more likely to deem statement a term than if the statement made by someone without such expertise, as in Dick Bentley Productions and Harold Smith Motors and Oscar and Chess 1957. In the case of Oscar and Chess, 1957, a bit about the facts of the case. Mrs. Williams purchased a second-hand Morris car on the basis that it was a 1948 model. The registration document stated it was first registered in 1948. The following year, her son used the car as a trade-in for a brand new Hillman Minx, which he was purchasing from Oscar Chess. The son stated the car was 1948 model, and on that basis, Oscar Chess offered £290 off the purchase price for the Hillman. Without this discount, Williams wouldn't have not been able to go through the purchase. 8 months later, Oscar Chess found out that the car was in fact a 1939 model and worth less than they thought. They brought an action for breach of contract, arguing that the date of the vehicle was a fundamental term of the contract, thus giving grounds to repudiate the contract and claim damages. It was held that the statement relating to the age of the car was not a term but a representation. The representee, Oscar Chess Limited, is a car dealer, had greater knowledge and would have been better positioned to know the age of the manufacturer than the defendant. So to look at collateral warranty, please refer to the contract law book on by Poole, pages 208 to 209. So written contract. If a contract is to be put aside in writing, any statement appearing in that agreement will usually be regarded as a term, and any prior oral statement that is not repeated in the written agreement will usually be regarded as a representation, due to the assumption that if a statement is left out of a written agreement, the parties did not view the statement as important, as in the case of Routledge and Mackay, as mentioned earlier, and Duffy and Oz and Newcastle United Football Company, 2000. Signature will usually make it difficult for the signatory to successfully argue the written terms of the agreement do not represent what they have agreed, as in the case of Lestrade and Grober, 1934. Oral contracts, incorporation of written terms. So when may written text be regarded as forming part of terms or of an otherwise oral contract? Incorporation must occur before contract is concluded, as in the case of Chapelton and Barry Urban District Council, 1940. Incorporation can take place on the basis of signature, reasonable notice, consistent course of dealing, and or shared understanding of parties. Generally speaking, it's harder to show incorporation the more onerous or unusual is the written clause, as in the case of Thornton and Shoe Lane Park in 1971. In assessing the extent to which clause is onerous or unusual, one focuses on the meaning and the effect of the clause in question, not the kind of type of clause, as in the case of Ocean Chemical Transport and Exnor Graggs 2000. And please refer to the contract law book on Poole, page 219 to 221. Interpretation of express terms. When construing meaning of contractual terms, courts attempt to ascertain the intention of the parties on an objective basis. In the case of Investors Compensation Scheme Limited and Bromwich Building Society 1998, Lord Hoffman stated that courts must look for the meaning which the document will convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. Ongoing debate about the extent to which background knowledge is to be taken into account. Traditionally, courts have been reluctant to take account of background material. Parole evidence rule. Where a contract is reduced to writing, neither party can submit evidence intrinsic. The contractual document alleging terms agreed upon but not contained in the document. For example, the rule in practice of Henderson and Arthur in 1907. Many exceptions to the rule were, for example, intention that the agreement be only partially written. If written, was not intended to set out all of the terms agreed between the parties. Intrinsic evidence of other terms is admissible. There is tendency nowadays for courts to infer, if possible, such an intention. Rectification is if the document is intended to record previous oral agreement but does not do so accurately, evidence of oral agreement is admissible. Parole evidence continued. Exceptions. Proof of custom or trade usage. Evidence may be admitted to prove a custom of trade usage that can cast light on how a term in the contract should be construed, as in the case of Smith and Wilson, 1832. Clarity, ambiguity, intrinsic evidence admissible to clarify ambiguity in express terms, show capacity of parties, so intrinsic evidence admissible to show in what capacity the parties were acting when they entered, for example, as principal or agent, and to show how contract operates, parole evidence admissible to show under the circumstances the written contract was intended to commence or cease, as in the case of Pine and Campbell 1856, support or rebut implied terms, parole evidence admissible to support or rebut any terms implied by law, collateral contracts. An oral statement can be deemed binding even when it is not a term of a written contract. If it gives rise to a collateral contract, if one party says that they will sign the written agreement, if it is assured that it is construed to in a certain way, two contracts may arise. The written agreement and a collateral-based contract on the oral statement. Classic exposition in the judgment of Lord Moulton in Helbut and Simmons, Court and Buckleton, 1933. Good example of device in operation is City and Westminster Properties Limited and Mudd, 1959. The device of collateral contract is a way of avoiding parole evidence rule, but device requires provision of consideration, which should usually be entry into the main contract. Remember, ruled on past consideration. So the entire agreement clauses, these clauses state the written contract contains the entire agreement. They are aimed at preventing one party subsequently claiming that an earlier statement is also part of the written agreement. These will be upheld by the courts, but do not exclude liability for misrepresentation. Significance of wording. Where possible words are given their natural and ordinary meaning, this may be departed from where this would lead to absurdity or inconsistency with the rest of the contract, as in the case of Shenandoah International Oil, London Co Limited against Mobile Sales and Supply Limited in a Court of Appeal case. 4 categories of implied terms. So implied by fact, implied by law, implied by custom, implied by trade usage. So terms implied by fact, these are terms that courts assume both parties would have intended to include in contract had they thought about the issue. They are implied on a one-off basis. 2 overlapping tests have been trade used to ascertain parties' intention. Officious bystander test. Officious bystander test if, while the parties were making the bargain, an officious bystander were to suggest some express provision for it in the agreement, they would testily suppress him from the common or of course, as in the case of Sherlow and Southern Foundries 1926, as Lord Justice McKinnon stated. Business efficiency test terms must be implied to make contract work. Leading case is the Moorcock 1889 case, and the later case is the Trollope and Coles Limited against Northwest Regional Hospital Board 1973, which makes it clear that the term only applied if the contract cannot work without it. Not sufficiently, that term makes contract fairer or more sensible. Terms implied by fact. Both tests are subjective in the sense that they ask what parties in the case at hand would have agreed, not what a reasonable person in their position would have agreed. So the term cannot be implied if one party was unaware of the subject matter of the term or facts on which it was based, as in the case of Spring and against National Amalgamated Steve Doris and Dockers cited 1956. Now, however, application of 2 tests have been supplanted by an objective construction approach stipulated by the Privy Council in Attorney General of Belize and Belize Telecom 2009, and this approach involves arriving at a proper construction or interpretation of the contract. And it was stated by Lord Hoffman, in every case in which it is said that some provision ought to be implied in an instrument, the question for the court is whether a provision would spell out in express words what the instrument read against the relevant background would reasonably be understood to mean. Terms implied by law. These are terms which the law requires present in certain terms of a contract, for example, not just on one-off basis and sometimes irrespective of the wishes of the parties. For example, tenancy agreements which include implied term that the landlord make it reasonable care to keep common parts of the property in good repair, as in the case of Liverpool City Council and Irwin 1977. Contracts of employment will include implied term that the employer will give departing employee a job reference, as in the case of Spring and Guardian Assurance 1994, an implied term that employer and employee will not act in ways likely to undermine the trust and confidence required if the employment relationship is to continue, as in the case of Malik and Bank of Credit and Commerce International 1977 and Crossley and Faithful Gold Holdings Limited 2000s. Statutes will also imply, for example, the sale of goods to consumers which have implied term that goods are of satisfactory condition or quality, and that's the Sale of Goods Act 1979, Section 14, Subsection 2, and Unfair Contract Terms Act 1977. Terms implied by custom. Terms can be implied if there is evidence to suggest that under local custom they would usually be present, as in the case of Smith and Wilson. Terms implied by trade usage, and these are terms routinely used in contracts with a particular trade or business, may be implied in other contracts, as in the case of British Crane Hire Corporation and Ipswich Plant Hire 1975. Identify 2.2. Identify the sources of contractual agreement. Contractual terms. Terms may be express or implied. Express terms are those specifically inserted in the contract by one or by both parties. They must be clear for them to be enforceable. As in the case of Scommel and Euston 1941, the fax was an agreement provided by the balance of price of the to be paid on the hire purchase terms over a period of 2 years. It was held that the words hire purchase terms were considered too imprecise, as the seller had a range of such items. Terms. Implied terms are not expressly included in the contract, but they are nevertheless still part of the contract. They may be implied by statute or by courts, or rarely by custom. An example of this is a contract of employment, which has been implied terms such as employers' duty to obey lawful and reasonable orders, as in Chapter 4. Express terms will generally override implied terms. However, some statutory terms cannot be overridden by express agreement. For example, terms inserted by the Sale of Goods Act 1979. Contractual terms in English law is a topic which deals with 4 main issues. Which terms are incorporated into the contract? How are the terms of the contract to be interpreted? Whether terms are implied into the contract? What controls are placed on unfair terms? The terms of a contract are the essence of a contract and tell the reader what the contract will do. For instance, the price of a good, the time of its promised delivery, and the description of the good will be terms of a contract. The Moorcock 1889 case. There was an agreement by a wharf owner to permit a ship owner to unload his ship at the wharf. The ship was damaged when at low tide. It was grounded on the bottom of the river on a hard ridge. The court implied a term into the agreement that the river bottom would be reasonably safe for ships to dry out on. Types of terms. So there are 3 types of terms: conditions, warranties, inanimate terms. And the distinction between the types of terms is important because it determines the remedies that may be available in the event of a breach. So 2.3 is to distinguish between these terms. So distinguish between conditions, warranties, and inanimate terms. And before we go on to doing this, I want to show you a video in regards to what the terms are. I'm going to share the video with you.
Contract law, contractual terms, conditions, warranties and innominate terms. Contractual terms can either be conditions, warranties or innominate terms. Traditionally, contractual terms were classified as either conditions or warranties. The category of innominate terms was created in Hong Kong Fur Shipping v. Kawasaki Kizun Kaisha. It is important for parties to correctly identify which terms are to be conditions and which are to be warranties. Where there has been a breach of contract, the remedy available will depend on whether it is a breach of condition or a breach of warranty. A condition is a major term of the contract which goes to the root of the contract. If a condition is breached, the innocent party is entitled to repudiate the contract and claim damages. Repudiate means to bring the contract to an end. In Poussard v. Spears, Madame Poussard entered a contract to perform as an opera singer for 3 months. She became ill 5 days before the opening night and was not able to perform the first 4 nights. Spears then replaced her with another opera singer. The court held this was a breach of condition as the opening night is a major event where all the critics would be present. Spears were entitled to end the contract. Warranties are minor terms of a contract which are not central to the existence of the contract. If a warranty is breached, the innocent party may claim damages but cannot end the contract. In Bettini v. Guy, Bettini agreed by contract to perform as an opera singer for a 3-month period. He became ill and missed 6 days of rehearsals. The employer sacked him and replaced him with another opera singer. The court held that Bettini was in breach of warranty and therefore the employer was not entitled to end the contract. Missing the rehearsals did not go to the root of the contract. The innominate term approach was established in the case of Hong Kong Fur Shipping v. Kawasaki Kizun Kaisha. Rather than classifying the terms themselves as conditions or warranties, the innominate term approach looks to the effect of the breach and questions whether the innocent party to the breach was deprived of substantially the whole benefit of the contract. Only where the innocent party was substantially deprived of the whole benefit will they be able to treat the contract as at an end. In this case, a ship being out of action for 20 weeks out of a 2-year contract did not substantially deprive them of the benefit of the contract. Even where the parties have themselves classified the term as a condition, the courts can override this. In Schuler v. Wickman Tools, a term of the contract between the parties was described as a condition. It provided that Wickman would send a salesperson to each named company once a week to solicit sales. This imposed an obligation to make 1,400 visits in total. Wickman failed to make some of the visits and Schuler terminated the contract for breach of condition. The court held this was wrongful repudiation as the term should have been classified a warranty. Contrast this with the position in Lombard North Central v. Butterworth where a clause relating to prompt payment was a condition. The defendant had leased a computer from the claimant for 5 years. They were late in making one payment. The claimant seized the computer and brought an action for the remaining installments totaling over £6,000. The court held that prompt payment was an essential part of the contract and therefore they were entitled to end the contract. The courts will look at the need for certainty in commercial contracts. In the Mihalis Angelos, an expected ready-to-load clause was a condition despite no loss suffered in consequence of the breach. This was because of the need for certainty in commercial shipping contracts. The decision in the Mihalis Angelos set a binding precedent which was followed in Bunge Corporation v. Tradax. Once a term has been classified as a condition in a particular type of contract, this applies to all contracts of that type. In summary, contractual terms can be classified as either conditions, warranties, or innominate terms. Conditions are major terms of the contract. Warranties are minor terms which are not central to its existence. A breach of condition entitles the innocent party to repudiate the contract and claim damages. A breach of warranty only allows a claim for damages and the parties are still bound by their contractual obligations. The innominate term approach looks to the effect of the breach and questions whether it has substantially deprived them of the whole benefit of the contract. If yes, it is a condition. If no, it is a warranty. This video is part of a series of videos on
So we could actually see from that video that we've just watched the distinction between conditions, warranties and inanimate terms, and the importance of this, because we looked at case law such as Poussard and Spears, Hong Kong Fire, the conditions in the case of Schuler and Wickman. We looked at the case of Lombard and also Mihalis and how it identified the difference between conditions, warranties and inanimate terms. And that's what we'll be going through now in more detail. So that video identifies it quite briefly for you with reference to case law. So 2.3, distinguish between conditions, warranties and inanimate terms. So the distinction between the types of term is important because it determines the remedies that may be available in the event of a breach. So conditions, these are the most important terms of a contract. Serious consequences if breached. Innocent party can treat contract as repudiated and thus is freed from rendering further performance of the contract and can sue for damages. The description in contract of term as condition is not necessarily determinative of question whether the term is conditioned. Courts tend to search for evidence that parties really intended term to be such, as in the case of Schuler, AG and Wickman Machine Tool Sales, 1974, as we explained in the video. The statute may determine that certain terms are to be treated as conditions. For example, in the Sale of Goods Act 1975, which provides that certain terms relating to title to goods and quality of goods are not just to be implied into consumer contracts, but also as to be conditions. Case law also determines that certain terms, typically standard terms in commercial contracts, are to be treated as such, as in the case of the Mihalis Angelos, as you saw in the video. The Court of Appeal expected readiness clauses in charter parties are usually to be regarded as conditions. A condition is an important term going to the root of the contract. Breach can result in damages or discharge of both. Discharge entitles the innocent parties to repudiate the contract and claim damages, as you saw in the video in the case of Poussard and Spears, 1876, where an opera singer failed to appear on the opening night, and it was held that this was a breach of condition which entitled the injured party to treat the contract as ended. Warranties. Warranties of lesser importance than conditions and can be breached without such serious consequences. Innocent party can sue for damages, but it's not able to terminate the contract. A warranty is less important, which is incidental to the main purpose of the contract. Breach of warranty results in damages only, as in the video Bettini case, where an opera singer failed to attend rehearsals, and then it was held that this was a breach of warranty. The injured party could not treat the contract as ended, and they were entitled to damages only. Inanimate terms, these can be either conditions or warranties. Breach of them can be serious or trivial depending on particular fact situation. If it affects serious, they are conditions, and vice versa. Notion of such terms first emerged in the Hong Kong Fair Shipping Company Limited and Kowalski, 1962, as explained in the video. An inanimate or determinate term is neither condition not a warranty. The remedy depends on the effects of the breach. If the trivial damages only term is treated as if it were a warranty, or if a serious damage, discharge, or both term is treated as if it were a condition. And the Hansard 1976 case, the facts was that citrus plum pellets for use in animal food had been sold for 100,000 under a contract which provided for shipment to be made in good condition. Part of the goods had not been so shipped, and in addition, the market value in such goods had fallen at the delivery date. The buyers rejected the goods, which were later resold pursuant to a court order and eventually reacquired by the original buyers for just under £34,000. The buyers then used the goods for the originally intended purpose of making cattle food. It was held that the Court of Appeal held the rejection was not justified. The term as to the shipment in good condition was neither a condition nor a warranty, but an inanimate term, and there was no finding that the effect of its breach was sufficiently serious to justify rejection. The buyers seem to have tried to reject, not because the goods were impaired, but because they saw an opportunity of acquiring them at well below the original agreed price. In these circumstances, their only remedy was damages. They were entitled to the difference in the value between damaged and sound goods. However, Hong Kong fair approach is far from dead, as in the case of Torwald Clavless, Arnie Maritime Corporation, the Gregors 1994. It may even apply in cases involving contracts for sale of goods, as in the case of Seahav and Bremer, the Hansard Note case 1975. The pool argues that instead of operating with 3 classes of term, one should just operate with 2 classes, such as conditions and non-conditions. 2D1, so this is for the extension activity. Analyze the court's approach to interpretation and validity of exemption clauses. An exclusion clause or exemption clause is a term that seeks to exclude or limit a party's liability for breach of contract. Common law rules, in order to be a valid, an exclusion clause must satisfy 2 conditions. It must be incorporated into the contract, its wording must cover the loss, and an exclusion clause can be incorporated into the contract by a signature, by notice, or by previous dealings. Signature is the case of Lestrade, Grogob, 1934, established that a clause is incorporated by signature, even if the signatory did not read or understand the document. However, the situation in Lestrade and Grobag, 1934, can be contrasted with Curtis and Chemical Cleaning, 1951, in which it was held that the signature does not incorporate the clause if the effect of the term was misrepresented. As in Curtis and Chemical Cleaning, 1951, liability for damage to a wedding dress was not excluded due to misrepresentation of the clause. A notice. For an exclusion clause to be incorporated by notice, reasonable step must be taken to bring it into the attention of the other party at the time the contract was made. What are the reasonable steps? Depend on the circumstances. As in the case of Thompson and LMS Railway 1930, the facts of this case were that T bought a railway ticket which stated that she would travel subject to the company's standard conditions of carriage. These conditions could be inspected at the station. One of them excluded liability for injury to passengers. T was unable to read and was unaware of the clause. She was injured and claimed damages. It was held that the ticket was a document which should be expected to contain terms, being more than a mere receipt for payment. The railway company had taken reasonable steps to bring the exclusion clause to passengers' attention by incorporating it in the contract document, which was the ticket. T was bound by the clause, even though she could not read. Illiteracy is a misfortune, not a privilege, as were all other passengers. As in the case of Ollie and Marlborough Court 1949, a clause can be incorporated by notice provided it was given before the making the contract. A notice in a hotel room did not exclude liability as the contract was made at the reception desk. Previous dealings. For an exclusion clause to be incorporated by previous dealings, there must have been a consistent cause of dealings between the parties. As in the case of Sperling and Bradshaw 1956, facts in this case is the defendant had dealt with the claimant for a number of years. On the contract in question, he delivered 4 full barrels for storage. As usual, he later received a document which acknowledged receipt and contained a clause excluding liability for negligence. When he came to collect the barrels, he found they were empty. It was held that the exclusion clause had been incorporated into the contract, even though it was received after the contract was made. It had been incorporated through the previous course of dealings, whereby he had been sent copies of documents containing the clause, even though he had never read them. However, Sperling and Bradshaw 1956 can be contrasted with Hollier and Rambler Motors 1972, in which 3 or 4 deals between a garage and a private customer over a 5-year period were held to be insufficient to constitute a course of dealings. The wording must cover the loss. Under the contra pro tem rule, the courts interpret the words narrowly against the interests of the person seeking to rely on the clause, as in the case of Photo Productions Limited and Securico in 1980. The facts of the case: a security guard burned down factory he was guarding. The contract between his employees in the factory orders limited employees' liability for injurious acts and defaults of the guard. It was held that the clause was clear and unambiguous and effectively limited their liability even for this fundamental breach. Statutory rules: even if a clause passes the common law test, it must also satisfy the statutory rules. This is contained in the Unfair Contract Terms Act 1977 and the UCTCC 1990. Unfair Contract Terms Act applies to exemption clauses in contracts made in the course of business. It states that a clause exempting liability for death or personal injury due to the negligence is voidable. Other loss due to negligence is void unless reasonable. Where there's any standard form or any contract between a business and a consumer, any attempt by a business to exclude or restrict liability for breach depends on whether the clause is reasonable. The burden of proving reasonableness is on the party seeking to rely on the clause. In assessing whether a term is unfair or unreasonable, the court has regard to the strength of the bargaining positions of the parties, whether the buyer received an inducement to agreement to the term, whether the buyer knew or ought to have known of the existence and extent of the term, and the ability of the party to insure against liability. St Albans City and District Council and International Computers Limited 1994, the facts of the case are the defendants had been hired to produce a computer system which would calculate population figures on which the claimants would base their community charges. The contract contained a clause restricting liability to 100,000. The database then that the computer system produced was seriously inaccurate, and as a result, the claimant sustained a loss of 1.3 million. It was held that the clause was unreasonable. The defendants could not justify the limitation of 100,000, which was small both in relation to the potential risk and the actual risk. In addition, the defendants had insurance of 50 million themselves. Therefore, it was reasonable to expect that those who stood to make the profit and had been well able to insure and had insured should carry the risk. Unfair terms in consumer contract regulations, UTCCR 1999, applies to the contracts where the seller is acting in the course of a business, the other party is a consumer, and the terms have not been individually negotiated. The regulations apply to all terms of a contract, not exclusion clauses. A term is unfair if it is not expressed in plain, intelligible language, and it is contrary to the requirement of good faith. It causes a significant balance in the parties' rights and obligations, and this is the detriment of the consumer. The term is unfair if it allows the seller to alter the terms of the contract unilaterally without a valid reason, which is specified in the contract of Schedule 3 of the UTCCR 1999. If a term is unfair, it is not binding on the consumer, though the rest of the contract can stand. So summary, so does the clause pass the common law rules? For example, is it incorporated into the contract? Does the wording cover the loss? If no, the clause is void. If yes, consider statutory rules. If the contract is made in the course of business, then you consider UCTA 1977 applies. If one party is consumer and the other party is a business, UTCCR 1999 applies in addition to UCTA 1977. If it's void, it exempts liability for death or personal injury, other loss, and void unless reasonable, unfair and not binding if not expressed in plain language, or if it causes an imbalance in parties' rights. And this identifies the issue around consumer protection. So some of the references that are used is Kaplan, London Sites, and Open EDU, Open Learn, and you could use, there's more additional reading on Moodle for you to refer to when looking at learning outcome 2 and referring to the issue of inanimate terms, conditions or warranties, or express or implied terms. So have a look at that and go on to Moodle for additional reading, as this will help you towards doing your assignment. And the next learning outcome is 3 that we'll be doing. Thank you for attending today's session.